Hello, everyone, and welcome back to the noon session. These are probably just a few pointers for us to catch up so that we don't miss out in this whole commercialization process. Like, for example, the instructors gave us some really important instructions and key points, like what is it some of the clauses should contain and what is the repercussion of overseeing these kind of clauses in your IP agreements. So these are some things which were very, very critical, I think, for practitioners, for beginners, for learners, not just in terms of practicing, but suppose we are, if it is our own intellectual property, how do we license it? What are the parameters we need to essentially see when we want to commercialize our own intellectual property rights? So these are some things which are a great takeaway today. I think
Yes, correct, madam.
I think we have Priya with us. Hello, Priya.
Hi, ma'am.
Hi. Could you please introduce yourself? Have you been here for the first time? Is this your first session that you're attending?
Yes, ma'am.
Great. Priya, do come online and introduce yourself. We would be happy to see you and hear from you. If possible, if you can just come online. I mean, that's up to you. But please introduce yourself.
I'm Priya, ma'am, pursuing my LLB and corporate.
Oh, wonderful. Which college, Priya?
It's Mahatma Gandhi Law College.
Okay. Nagaraju, do you guys belong to the same college?
Yeah, ma'am. Yeah.
Excellent. Oh, wonderful. And Priya, are you also pursuing the corporate law program at NALSA?
Yes, ma'am. She is one of my colleagues also.
Oh, wonderful. Good.
Ma'am, can you briefly explain about drafting? I mean, we are in the first year of pursuing the LLB. I
Okay.
mean, slide. Can you briefly explain about drafting, how it is to be?
Sure. So, you all have studied contracts, right?
Yeah, ma'am. First
I'll just give
basics.
you a very, very brief introduction of where we are discussing today. Okay. So I'll just map you. Maybe I'll not be able to explain completely about drafting, but in about 2 or 3 minutes, I'll just explain to you where we are and what part of the subject we are discussing. So you have all studied Contract Act, the Indian Contract Act. Am I right? So that is something which Ashok was also mentioning in the morning. This is based on something called the English common law, English common law system. So we have contracts. If you look at the Canada law system, or if you look at the Australian law system, they're pretty much the same. Just a moment. Hello, Ashok. Welcome back.
Good afternoon, ma'am.
Good
Sorry, I got a
afternoon.
little late.
No problem. No problem at all. So here we have two students, law students, who have Nagaraju and Priya. They are both law students, and they have been really nice, interacting in the sessions and getting to understand the subject. But they had a simple question, to asking what exactly is this contract drafting all about. So I was just giving them a very, very brief introduction and sort of mapping them to what we are discussing today.
Sure.
Nagaraju and Priya, you have studied Indian Contract Act, right? So which is pretty much based on the English law, like Ashok was discussing this morning. So if you look at this Contract Act, there are two components to this. One part of what we call as the general principles of contracts, and there's something called a special contracts. You must have studied both. Am I right?
Only general principles we have studied, ma'am.
You have studied, but maybe you will be studying special contracts probably in your subsequent semesters or whatever. But if you looked at the general principles of contract, tell me one thing. Now, there are so many types of contracts. Even if you just name a handful of them, you may say insurance contract, or you may say intellectual property contract, you may say construction contract, some business commercial contract. Even just selling goods and services are all contracts. But what we see is we don't have something like a one size fit all. If I say draft a contract for all of these, I cannot have a template and say this is the common thing for everything, right? So each contract, there is nothing like a one size fit all for anything. Every contract is different in itself, and it's very party centric. So whatever the parties want, the way they want the contractual relation to go, they try to put that together in the agreement. So we cannot apparently have a subject which says contract drafting, right? So what the law does is, what contract law provides us is, it provides us a framework. That's why you use the term general principles of contracts. right? It's the basic principle, the underlying principle. So given any of these contracts which you see across, whether it is a commercial contract, whether it is something to do with insurance, whether it is something to do with any other forms of contract, there are certain guiding principles. There are some basic principles which you ought to follow. Like you studied something called offer acceptance. Then you also discuss that consideration is most important. If you don't have a consideration, then why do you even want to enforce it? So if I gave you something free of cost, you don't even have anything to go back against me saying that whatever she gave me, whatever she provided me was a bad product or whatsoever it is. So you really don't have a reason why you want to come back to me and claim unless that's the contractual part, but unless that caused you harm or something that takes you through some other tort actions or whatsoever it is. So this is why we called it as general principles of contracts. What you study here at your college level is general principles. Now you cannot this is something which is already laid down. This is a foundation for you. Now what we are discussing through these classes it is now specific to IP. Intellectual property. Now, what happens in intellectual property? You cannot just create. Why do you want to have a patent? Why do you want to have a trademark? Why do you want to have a copyright? Number one, you may want to make use of it yourself. You may not have studied intellectual property yet, but you are making an attempt to understand IP, which is a very good thing. So why would you want to have a patent or a trademark or a copyright, right? For example, you came up with a very innovative technology. What will you do with that technology? You got it patented. What will you do with the patent?
Maybe for the commercial use.
Exactly. You want to commercially use it. You want to commercially exploit it, right? So you are given a term, you are given a 20-year term or whatsoever it is to say that you have the exclusivity. It is only you who can exploit this innovation to the best possible extent. Now, when you want to commercialize all these things, you have to apparently either make use of it yourself. That is, you will manufacture it, you will distribute it, you will sell it all by yourself. You have the whole infrastructure to do that. Or the other alternative is you don't have the infrastructure or you want many more people to participate with you in the distribution process. So you want this product to go pan-India. You cannot apparently do it all by yourself. So what you do, you give some of your rights. Like, for example, you are parting away some of your rights to somebody. Let us say you are giving your manufacturing rights to Ashok. You don't have the wherewithal. You're a lawyer. But you did some innovation and you brought about a technology. And Ashok is the engineer. So what you do, you give the engineer certain rights, telling him that you can manufacture this and maybe you can even sell it or whatever it is. And you get a small, and you get some kind of a royalty, you get some kind of a commission or whatsoever it is you are going to share. So that is very contractual between both of you. When you say, now I'm going to give some of my rights to Ashok, you have to enter into a contract. Now, while you are entering into the contract, this is exactly what we have discussed all of today, right? So contract drafting was the most important part. How do you draft the contract? Now you become the lawyer, right? You are the lawyer. So you are going to identify the most important elements of what goes into this contractual relation between you and Ashok, and you start to get into the contractual agreement. So that will determine your relation between the parties. For how many years you want to have this contract? What is it that you want to give Ashok as rights? You have the complete right, you have the complete ownership, and you have the possession of this intellectual property, right? So how much of that are you going to give Ashok? That becomes the question. I hope I've been able to explain this to you very briefly, though.
Yes, ma'am. Yes, ma'am.
Okay, does
Thank
this
you,
make
ma'am.
Yes.
for you? Okay, okay. Now, what we are going to be discussing is how this technology transfer is actually being done, right? So, Nagaraj now is going to give some technology. He's going to transfer some technology of what he has, let us say, to Deepak, right? Now, how is the technology going to be transferred? It's not by word of mouth, because today you will say something, tomorrow something else will happen. So we have to put everything to a documented form. So what are the different ways in which these technology and know-how will be transferred from one party to another? So you may say transfer or transferee or whatever name you call them as. That's what Ashok is going to discuss with us in this session. So over to you, Ashok, and sorry for eating up some time of your session.
Not at all, ma'am. Not at all.
Yeah.
Not at all.
That is very good, madam. That will help us.
Thank you. Thank you. All right.
Okay. So I think the broad concept of what the theme of the next conversation is, I think, has already been very well covered by Dr. Pratima. So it makes my job significantly easier as we go into this conversation.
Thank you.
So if any of you have had a chance to follow the news around defense tech in the country, you would have probably come across a news article sometime of 2023 May, if I remember correctly, that the American government and the Indian government are in talks to undertake a transfer of technology for jet engines, fighter jet engines. Right now, this buzzword TOT, or transfer of technology, has proved to be one of the measures of diplomatic relations, bilateral trade, and today tech equals political and economic clout in the global stage. So there's a reason why people are now trying to invest in semiconductor manufacturing in India, because they realize that reliance on Chinese semiconductor infrastructure in itself is a security vulnerability. So in this kind of a climate where tech and national interests are intricately linked with one another, one of the key instruments for ensuring that countries are able to achieve better clout for themselves economically and politically is the tech transfer agreements. Right now, why is this very important? Right? So let's just take a step back before I start the presentation. All of you are familiar with the Russia-Ukraine conflict?
Yes.
Okay. Now, there was tremendous pressure on India to take a very, very vociferous anti-Russia stance when the Russia-Ukraine conflict started. Right? And why did India not do it? The reason why India did not do it is that a good 30 to 50%, if not more, of India's defense infrastructure, including weapons and armaments, is dependent on Russian tech support. Right? We don't own the IP on that. Because we don't have the inherent IP on it, we have to depend on somebody else to keep our equipment upgraded, up to speed, well maintained, have the accessories available, have the patches available. Now, this made India's foreign policy that much more difficult. Take it the other way around. When the whole subject of India going to the moon started, there was also considerable pressure on India to decide whether it's going to join the moon base initiative of China and Russia or the Artemis Accords of the United States. Now, what also swayed India's eventual decision to join the Artemis Accord was the fact that buying into the Artemis Accord enabled you access to the entire IP portfolio of US companies when it comes to space exploration, which would otherwise not be available the moment you jump ship and go to the opposite side of the camp. So all this really tells you that the self-reliance initiatives of 2020, or the Atmanirbhar Bharat schemes as they're known, they go beyond just fostering an industry domestically. It is to ensure that the overall interests of the nation as a whole is independent of its technology requirements. Right? So if you have complete self-reliance, you're also then in a position to plan your activities as a nation without having to worry about how it might affect the suppliers of technology to you. Now, that was the basic initiative. Right? Now, keeping this context in mind, let's jump into the tech transfer agreements and how they actually work in reality. Okay, technology transfer agreements, right? So let's first start with a question. All of you, we did dwell upon licensing and assignment in some degree of detail today morning. Why do we, what
Ashok,
is the difference?
sorry
Yes,
to
ma'am.
interrupt. The later part of the session also, the second session also, we had quite a bit of discussion around licensing or assignment and the kinds of.
Perfect.
Yeah.
Perfect. So you've already had some insight into what licensing is, what assignment is. Now, what do you think is the difference between a simple agreement for licensing of intellectual property versus a technology transfer agreement? Anyone? Deepak, you want to take a shot at the answer to that?
No, actually, just I am thinking for that. That's okay.
Okay.
Nowadays, lot of life. I mean, technology transfer activities are going on. Like Rafael, also they wanted to make it. G also they wanted to make this what is called the engine for India for the fighter jets.
Right.
So, what should be the actual condition that what should be the means as what it is a technology transfer. So definitely in the technology transfer means what they have used. Of course, India is also tried to make the engines by DRDO, but it was not successful ultimately. So now I think Rafael, this team, they are trying to modify. Okay, we can help it. GE on the other hand also come, but I am not exactly able to tell that how it should be. Means what does exactly
Okay.
means technology transfers.
Okay. So
So
let's
what is the pros and cons behind that?
let's take a step back, right? Now we'll use the fighter jet example. India
Yeah.
has purchased a variety of fighter jets from a variety of countries, right? So we have
Yes.
the Sukhoi and the MiG aircrafts from Russia. We have
Yes.
the Jaguars and the Rafales and the Mirages from France.
France.
We have the
Rafael is also
Dornier.
France.
Correct. Now we have Dornier aircrafts from the US. Now, when somebody sells me a plane, right? My layman's thinking is if I open up the plane, I know exactly how it is built. So why am I not able to manufacture these fighter jets on my own? Why do I need a tech transfer agreement with a Dassault or with a MiG company for
G.
the
Or
tech
G.
transfer? Yeah. So why do we need it, right? Ultimately, we are buying the product. How difficult is it to open up the product and reverse engineer the whole thing and then build something on our own?
In my opinion, you see that this type of technology transfer, because there are some parameters which is to be on the high risk of these things. Suppose if any material, because why we are calling I mean space technology, it is the ultimate space.
Right,
So
right.
we consider some parameters into that, but that parameters, whether it is suitable or not at at the air, because we not at the ground we can measure all the parameters, any risk and everything parameters we can measure it.
So,
But in the air,
so
how it is
the
possible to maintain?
so see
So
the risk and safety component is the next leg of the problem. The first question is, can
yes,
we even rebuild something from scratch by reverse engineering what has been already supplied to us? Bear in mind that the Chinese have done this very successfully with the stealth aircraft, which is I think the
yes,
J-20 fighter jet. So
yes, yes, yes.
there is precedent for somebody taking a plane that already exists, opening it up, and then reverse engineering it to build a fighter jet of their own. So why are we not
Correct.
able to do it? Right? What's the difference between a transfer of the plane versus the transfer of technology in that plane?
No, we cannot say that's India could not do in the DRDO. They have the successful also
Uh,
partially. They are also trusted by
let's
Russian.
let's I want you to keep your background knowledge of DRDO aside, right? Why are we not able to build a Rafale aircraft on our own? Right? We are buying it,
Yeah.
but we're not able to build it. What is the reason you think that's happening?
Maybe infrastructure.
Infrastructure, okay, that's one good option. We
Maybe
don't
the
have,
proper technology we don't have.
okay, proper technology we don't have. Okay, what else? Okay, all good answers, right? Now, this is not just specific to fighter jets, right? Even if we take an Apple iPhone, fact of the matter
Yes.
is that there is only one Apple iPhone that's ever been built. And while Samsung might have its Note and its S series of phones, fact of the matter is that none of these phones, despite a lot of countries buying these phones, no domestic brand has been able to recreate an Apple iPhone or a Galaxy Note series. Now, the reason why this happens, and you will notice that a lot of these technologies are covered by patents. So, if you go to the relevant patent office website of the United States government, today you can notice, for example, that Apple's proposed car, it's called the Apple car, has 57
Yes.
odd functional utility patents that are already filed. A patent essentially means that the technology nitty-gritties are being disclosed to the IP office in return for the grant of the patent. So it's not very difficult for me to access what those patents disclose and what is the underlying tech behind the Apple car itself. Yet that will not be sufficient for me to build a car, because what the patent application discloses is the broad conceptual innovation of the car. But the nuts and bolts of how the technology is developed, what is the material used, what are the alloys employed in those materials, how the manufacturing is done, what are the sensors, what are the software that's gone into it, the coding for that software. These are things that you will not find in the patent application, right? So it's one thing to say that I have a fourth generation fighter jet aircraft technology that I have and I'm building a plane. But knowing how to actually build those components, how to actually assemble the aircraft, how to actually put the whole thing together, that know-how is the missing piece that the patents will not disclose. Right? Now, why we call it transfer of technology is that you're not just giving a fighter jet as it is to the Indian government. What you're also doing is working with the Indian government to develop that infrastructure, develop the local knowledge base and skill set necessary, and to essentially bring the entire knowledge base necessary to build the aircraft from scratch. Right? Now, that is what distinguishes a simple licensing of IP over a technology transfer. Licensing of IP is very simple. I have a patent, you take the license. But with tech transfer, what I'm doing is I'm saying that you please take the license for my patent, but along with that, you also get access to the knowledge in my head, which I'll use to work with you to ensure that what is in that patent actually translates into a market-ready product. Okay. Now, this is what distinguishes a IP transfer simpliciter over a technology transfer. Because with tech transfer, IP is a component. But with IP is the whole and soul of the IP transfer itself. Okay. This is the fundamental thing that we need to understand. And this is what we will dwell into in the first leg of the conversation. Now, the second leg of the conversation today will be about the technology transfer agreement, because there are some very peculiar issues to tech transfer agreements, which will probably not be true for other kinds of IP licenses. And that is something that we have to dwell into. And the third thing that I want to dwell into is that it's very important for us to understand that technology transfer is IP and a lot more, right? Because the moment we dwell into the subject of technology transfer, there is a variety of legal and political and economic considerations that comes into the picture, which will eventually determine how viable the technology transfer agreement is, what is its enforceability, the risks associated with the tech transfer agreement. All of that gets affected by not just one stream of laws, but a multitude of laws. Now, this is the third component that we'll be dwelling into. Right? So let's go into just deep dive into it, right? So the first step towards a technology transfer agreement is to map the expectations of the transferor of technology and the transferee of technology. Now, let's take an example of the transfer of technology policy of the Indian Space Research Organization. So they had a tech transfer policy. The tech transfer policy essentially talked about outward tech transfer. ISRO developed technologies going out into the market. Now, what are the possible considerations here? ISRO is obviously looking at a revenue stream, but the revenue stream is not for the purposes of achieving a profit of some margin. The revenue stream is essentially to justify the cost of development. But the larger objective of the tech transfer policy is to ensure that spin-off technologies are able to proliferate and the country as a whole becomes more technologically self-reliant. Now, in a scenario of this nature, the tech transfer agreement between ISRO and the transferee would probably take on the contours of a public policy initiative, as opposed to being driven by a pure commercial decision-making process. On the other hand, it could be a scenario where there's a demand for a particular product in India. The technology in that product is not available with a local manufacturer. He goes to the foreign owner of the IP. That foreign owner of the IP is then agreeing to transfer technology, either to enable the Indian transferee to develop a product and sell it in the Indian market, pay a royalty in return, or the transferer feels that he wants to enter into the Indian market, but it is too cumbersome to actually physically set up shop. Rather, find an Indian counterpart, give him the technology, take shares in the company instead, and then reap the dividends of what the company makes. Right? Now, here the considerations are purely commercial. Now, the other scenario could be that the transferee of technology is merely looking to raise some investments on the basis of the fact that they have this technology which nobody else does. And on the strength of it, they want to go to the market to investors and say, I need the seed capital. This is a return on investment I can promise. Now, in a situation like this, no investor will put in money into the transferee company unless the transfer is able to show that under the technology transfer agreement, they have some irrevocable rights in the technology. So, in a situation like this, the entire model for the tech transfer may change. So, mapping the expectations of what the licensor is looking to achieve or the transferor is looking to achieve, what is the transferee looking to achieve, what is the public policy considerations or the commercial considerations. This is the first step towards a tech transfer agreement being drafted. Any questions so far?
Sir,
Now,
can you explain about royalty rights?
we'll come to the royalty in a little bit, right? So currently we're just looking at the fundamentals now. The next leg of the conversation, we will go, in detail into royalty, licensing fee, and consideration. Right? So currently we're just saying that if you're going to sit down and start drafting a tech transfer agreement, what do you have to keep in mind? The first thing to keep in mind is the expectations of the transferor and the transferee. Okay. Now, right after that, you have to do a due diligence into the IP itself. So let's take the example of a Tesla electric vehicle. Right? So in the Indian government says that unless you're manufacturing EVs locally, we will not allow you to do business in the electric vehicles market. So Tesla says that, okay, this is too difficult for me to set up a manufacturing facility. I will find a local manufacturer, I will license the technology, and I will allow them to manufacture and sell in their country. Right? And that is the background to the entire tech transfer agreement. Now, if I am the licensee and the licensor or the transferor comes and tells me that this is the royalty that I want or this is the money that I want, the first thing that I want to ensure is that what Tesla has in terms of IP, no other company has the same IP. And therefore, by taking this technology transfer, I'm actually able to acquire a monopoly. Okay? Because tomorrow, if I go to the market and say that, look, I have a certain electric vehicle which has an increased range of, say, by 100 kilometers, because I have access to some proprietary technology of the foreign transferor, only for me to realize that a competitor of theirs in India has managed to have the same IP to ensure that the range increases to 500 kilometers. Then essentially the entire tech transfer agreement is a waste of time. Right? So this is the verification that I have to undertake. Does the transferor of technology have IP? Is there a monopoly on that IP? Is it registered? Is it unregistered? How much of it is a trade secret and confidential information? How much of it is a patent? All of these factors I have to assess. Only once I'm fully convinced that the transferor is the absolute owner of the IP, he actually has a monopoly over the IP, the valuation therefore is justified, will I then go into the next leg of negotiating the commercial terms and conditions. Right? So the next step towards drafting a tech transfer agreement is to do this due diligence exercise into the IP background. Is the transferor the owner? Is it worth the money that the transferor is claiming? Are all the registrations in place for the IP? And more importantly, is there anybody else in the market which has already managed to develop similar technology, therefore rendering the transferor's technology economically unviable to me? I have to ask myself all these questions, undertake the inquiry process. Only then do I realize that, is this something worthwhile for me to explore in the form of a tech transfer agreement? Right? Now, for certain kinds of products, there are also very unique risks when it comes to markets. Right? I'll give you an example. Let's take a situation where a life-saving COVID drug is now being licensed to me under a tech transfer agreement. I'm getting the formulation, I'm getting the know-how on how to manufacture the drug, and it's got a great application. Right? Now, in the health and pharma sector, the one thing to remember is that the government of a country like India has tremendous amount of powers for something called as compulsory licensing. essentially means that generics of these drugs can be manufactured with very little difficulty through the channels of a compulsory license. And the likelihood of something like that happening to defeat the investment I make is pretty high in a country like India, because healthcare in a developing economy is different from healthcare in a developed economy. So as part of my IP due diligence, I also have to identify market-related vulnerabilities. Is this application is it going to carry some unique risk elements? What are those unique risk elements, right? Or for example, if I'm looking at a scenario where I'm developing self-driving cars, okay, in a country where women are not allowed to drive vehicles without there being male accompaniment. The question for me is that will self-driving cars be construed as an indirect way to violate the rule against women being allowed to drive cars on their own? If the answer is yes, then I have to see whether the tech transfer agreement is even viable for me or not, right? The merits of such a rule existing in the first place, that's a separate debate. Bottom line is certain kinds of technology have cultural sensitivities, market sensitivities. Mapping those is as critical to the exercise of IP due diligence as it is to undertake the legal due diligence around IP itself. Any questions so far? So to give you another example, if there is a particular kind of drug that has applications in the field of reproductive health, you could have a scenario where a country like Ireland, driven by Catholic sensibilities, they may not be very open to recognizing a product of that nature proliferating in the market. So tech transfer agreement to enable the party to manufacture and proliferate those kind of drugs in the market could very well be considered as unlawful. So you will have to be very sensitive to the kind of technology you're dealing with and the applications, and then basis that take a call on what the risks associated with that IP is. But without this due diligence to deep dive into the nuances of the tech transfer agreement is probably not the wisest idea. The next thing to also examine is the applications of technology. The reason why I say this is that in certain kinds of industries, the technology could have what is called as dual use implications. It could have civilian and defense applications. A great example of this is aerospace and space technology, where some of the technologies like propulsion technology can be used either for a satellite communication technology, or it could be equally used in ballistic missile. Now, in a situation like this, these tech transfer agreements are governed heavily by export control regulations. It could be the US ITAR, it could be EAR, it could be the SCOMET list of the Indian government. It could be any one of these export control regulations that comes in the way. So doing that legal due diligence outside of just the IP title verification also becomes very, very important, because understanding these barriers will then help you determine are there factors beyond the control of the parties that will affect the tech transfer agreement, right? Now, once you have managed to map the applications, you have done your IP due diligence, identified the legal landscape as a result of step number 1 and 2, which is IP due diligence and mapping the applications, you will also then have to look at what is the economic and political climate in the tech transfer destination. The reason why I say this is because in China, for the longest of time, if you were setting up a joint venture company for the purposes of implementing a tech transfer, right? Design is in India, you want to set up a manufacturing facility in China. Some of the Chinese regulations around the joint venture formation dictated that the IP over the improvements and modification remains in the Chinese joint venture and not with the Indian parent entity. Okay. Now, why is this regulation there? Because China is obviously aggressive in its effort to develop indigenous capabilities and indigenous IP. There is, in fact, a rumor that at one point of time, patent examination was sought to be outsourced by the US Patent Office to a different jurisdiction. And one of them rightly pointed out that if something like this were even contemplated, a country like, say, China would be very interested in doing the patent examination process from within their country, because it gives them a ready peek into US technology, which then allows them to develop spin-offs of their own. Right? So sometimes knowing what the political climate is in the transfer destination of the IP transfer or the tech transfer also helps you manage the risks a little better. Right? So before you get into the tech transfer agreement drafting process, this is the homework that you have to do. Right? Just the knowledge base that you need to develop around the tech transfer agreement before you deep dive into the drafting process. Any questions so far? So a big chunk of the tech transfer agreement also comes to the question of valuing the technology. Right? Now, something like, say, a real estate asset, valuation is not rocket science, right? So if I have to value all the land in, say, MG Road near Bangalore, I just go to the local sub-registrar's office, find 10 registered sale deeds for properties in that area for the last 5 years. And then basis that, I come to an understanding of what the prevailing market rate on the property is, right? But valuing technology is an extremely complicated exercise, and there are designated valuers, professional valuers who do this job. Now, why valuing technology becomes very important? One is the obvious question of royalty computation and licensing fee computation. You have to negotiate the economics. How much money will I pay for the transfer of technology? Knowing what the value of that technology is becomes very important, and that's why you need a valuation exercise done. But in addition to that, you have to always remember that, especially when it's a cross-border tech transfer, where it is somebody on the outside transferring technology internally, or somebody from India transferring technology externally, there is an immediate impact on fiscal deficit if there is an improper valuation, right? If more money goes out than what the tech is worth, then essentially India's fiscal deficit problem takes a little bit of a hit. So similar with technology within India being externally licensed without there being adequate consideration. There could be concerns around FEMA and foreign exchange, right? Are you valuing your IP properly or not? So having a scientific approach to the valuation game is very critical, right? Parties' autonomy gets a lot of recognition from the point of view of regulations. But in two instances, especially, the valuation will have to be backed up with some evidence. The first instance is when you're getting equity in a company in lieu of technology transfer. So let's assume that it's a foreign company that's looking to license its technology to an Indian company, not for payment of money in return, but for allocation of shares in the company that is getting the technology transfer. Now, if the technology is worth 100, but the shares I'm getting is worth 50,000, then you have a problem, right? Because what is going out of the country versus what the country is getting in response, there's no parity. So in a situation where you're trying to transfer technology for allocation of equity, it's very important to ensure that there is a proper valuation exercise done as per the regulations. It could be the FEMA, it could be rules and regulations under the FEMA, it could be the FDI policy, whatever it may be, the valuation will have to be backed up with some solid data. The other is when it's a scenario where it's a subsidiary company in India and the holding company is transferring technology to the Indian subsidiary or vice versa. So these are what we call as related party transactions, where there are some common owners, common directors between the transferor and the transferee. Now, in a situation of this nature, transfer pricing under the Income Tax Act becomes very critical. Because obviously, if the two parties are related, chances are that the entire technology transfer transaction is not happening as per market rates. It could be happening for a special consideration. But by virtue of the Income Tax Act, the transfer pricing authorities have the powers to look at arm's length transactions in the market for the same kind of technology and then come back and reassess the entire valuation for taxation purposes. So it's very critical to understand that, especially in cross-border tech transfers, or in case of tech transfer involving equity allocation for technology transfer or between related parties, the valuation cannot just be whatever the parties decide. It will have additional nuances which will require the report of a professional valuator recognized under law, right? And recommending this to the client, right? Because as lawyers, we don't always do the valuation exercise. At least in India, in my experience, lawyers never do the valuation. But having the client understand that in certain situations, they should work with a proper valuation professional becomes very critical because it will then go to the root of the legality of the agreement itself, right? And the enforceability of the agreement. Any questions so far?
Sir, if the valuation is difficult, then who will give the valuation, sir?
So there are professional valuators. There are a recognized brand of accounting professionals whose only job is to do a valuation exercise. So you will find, for example, valuers within an Ernst& Young or a PricewaterhouseCoopers or a KPMG. So a lot of these accounting firms will offer this as a service where they will do a valuation exercise, get it approved by the concerned regulatory authority so that the tech transfer valuation is no longer called into dispute at a later date. Right? So you can always look up some of these professionals available. They're fairly easy to find, and they can then do the valuation exercise. Does that answer your question, Nagraju?
Yes,
Yeah,
sir.
just
Sir.
wanted to add here. So tomorrow we have a very specific session dedicated to IP valuation, where we have an IP professional who will just briefly explain what the lawyers need to understand of IP valuation. So there's something yet to come on IP valuation. This is just
Perfect.
a brief introduction. Yeah.
Perfect. So you will have, for example, different approaches that the lawyer has to be familiar with, the market-based approach, the cost-based approach, which anyway will be dealt with in detail tomorrow.
Right.
The actual nitty-gritties of how the numbers are finally defined, as I said, that's a specialized field. It's always good to work with the specialist rather than trying to do that as the contract professional, right? So this is the known unknown. We may not know the valuation exercise ourselves, but we need to know that a valuator's report is relevant, right? So that's the reason why the homework becomes important. Clear so far, Nagaraju?
Yes, sir. Thank you, sir.
Okay. Now coming to the agreement, the first thing to look into in the agreement is how do you define the technology? So if you remember in the morning, I was describing a case study in which greeting customers with smile was actually described as a technology. Okay? So having a proper definition is very important because if you end up trivializing the technology being transferred as part of the transfer pricing agreement, then you may end up having a problem of enforceability at a later date. Okay? To give you an example, Ghana has, if I'm not mistaken, specific laws dealing with technology transfer agreements. Now, one of the things that the law says is that if the transfer of technology agreement relates to a technology that is freely available in Ghana, then the agreement's enforceability is going to be suspect. Right? Because essentially that means that you don't need the tech transfer agreement to begin with, right? It's freely available. So you need to ensure that the proprietary element of the technology is properly defined within the definition of the technology within the agreement. Right? But if the definition is going to be framed in a manner that seems to suggest that there's really no proprietary rights over the tech, then the question arises as to what is the point of even entering into the tech transfer agreement. Tomorrow, the transferee could very well say that I don't need this agreement anymore. I will go ahead and do what I have to anyways, right? So the definition of tech must be precise, must be nuanced, and all the technical jargon must be explained in non-technical jargon. So never assume that if there is going to be some complicated modeling of an AI, which is being licensed as part of the technology, you don't want the agreement definition to be couched in so much of technicality that the judge is not able to later understand what is being transferred. Okay? So having that properly defined in the agreement is very critical. And I'll give you an example of how this can go wrong. We were litigating a confidentiality clause violation in a tech transfer agreement. And the problem for the plaintiff, and we were for the defendant, was that the definition of what is actually sought to be protected in the agreement and how it was defined in the complaint before the court was so vague and was so poor, the entire injunctive relief got refused only on that one ground. That if I don't know what is the accusation being made against me, which is what is the tech of misappropriated, how do I even defend it to begin with? And based on that one argument simpliciter, the entire injunction application got set aside. So it's very, very critical to ensure that you apply your mind to how you define the term technology within the tech transfer agreement and ensure that it is drafted in such a manner that it is easily ascertainable by a non-technical person tomorrow. Right? The other thing is that the tech transfer obviously is not just handing over of IP, it's a package. Now, what does that package comprise of? The entire tech transfer package comprises of A, licensing or the assignment of intellectual property rights. It could be patents, it could be confidential information, it could be trade secrets, it could be copyright, it could be a whole bunch of things that you specifically identify. Then you need the know-how. Essentially, what is not covered in those registration documents, what is not borne by the documents, which is in the realm of the human intellect. That is what you critically need, because I can get a patent application off the internet to know what the technology is about. But how do I turn that into a product is where the know-how comes into the picture. Having the agreement specify that the know-how is also being transferred either through assignment or licensing is very critical. Now, in addition to that, you could have services being rendered as part of the tech transfer package. So, for example, the services could be some kind of mentorship as part of the know-how transfer. It could be, for example, a periodic visit to undertake upgradation and maintenance of the technology itself. Right? And undertaking the training of employees and the workforce. All of this could be the services that is coming to as part of the tech transfer. So in the context of a fighter jet tech transfer, one of the things that will have to be provided as a service is the training of the maintenance staff involved in the maintenance and the upgradation of the aircraft itself. Right? The same could be equally true with an electric vehicle technology. You need a pool of automobile engineers being trained to undertake the maintenance of the car. Right? So having those things, those parameters and those services being clearly identified becomes very important and very critical. Right? It could be quality control and audit as part of the package, where you not only provide the license to the IP, the know-how and the services for training, but you come in once in a while, you undertake a audit to verify whether the quality control measures are in place, are they being properly implemented or not, right? All of those things that you will have to examine to ensure that your tech transfer is translating to a market-ready and market-competitive product. The quality control and auditing could be part of the tech transfer packaging. The last part, of course, it could be management services, where, for example, you're managing the production lines, you're managing the supply chain, you're structuring the procurement contracts for the raw materials needed to produce the products based on the tech transfer. So all of those things could be part of the tech transfer agreement. Right? So every tech transfer has technology. That technology will not just be defined in simplistic terms like electric vehicle cars, right? It will comprise of a package of intellectual property, know-how, services, quality control, auditing, management, and so much more. Understanding what this package is the diligence that a lawyer has to exercise by sitting down with the clients and gathering all this data and information. Any questions so far? Now, the next part, of course, is the licensing of the IP in respect of the tech, right? Because every tech transfer will involve some level of IP transfer as well. Now, broadly speaking, every licensing exercise within a tech transfer agreement will involve three things. One, you have to determine if the transferee is going to be exclusive or non-exclusive licensee to the IP. If the transferee wants to be an exclusive licensee, the transferor will obviously want a lot more in terms of what he's getting in response, be it royalty or licensing fee, right? If the transferee is going to be non-exclusive, then the transferee will obviously negotiate on how much royalty they're going to pay, because essentially they'll have other competitors within a very close vicinity. So having that exclusivity and non-exclusivity clearly defined is very critical, right? The next question is your rights as a licensee. What is the geographical extent of those rights? Is it India specific? Is it Asia? Is it Europe? Is it Nordic region? Is it MENA region? You have to be very, very clear in defining the limits of the boundaries within which the tech transfer rights can be exercised. And three, you also want to define the activities that can be undertaken as part of the tech transfer license, which is manufacturing, sale, advertising, marketing, servicing of the product post-sale, undertaking upgradation and maintenance, perhaps even going out and conducting trainings yourself to the ultimate customer on how to use the product, how to maintain the product, how to manage the product. So the full range of activities that are to be undertaken under the license has to be also very clearly spelled out. Right? It's clear so far, these three components are around licensing of IP within the tech transfer agreement. So now we come to the consideration, right? Now, consideration in my experience is broadly divided into 4 categories. One could be a mere lump sum amount where they say, I pay you this much money, I take over the technology, then I do what with it, you don't get to interfere anymore. In my experience, this kind of tech transfer agreements are very rare. It's almost, at least I have never come across any lump sum outright transfer agreements. What I usually come across is the royalty and licensing fee arrangements. Now, what exactly is a royalty and licensing fee arrangement is that there is a fixed component or an upfront amount that is paid as a consideration or an advance of sorts for the tech transfer. And thereafter, a certain computation equation is arrived at where it says that if the transferee undertakes the sale of a product, the product will be sold at a particular price and X percentage of that price will be paid to the transferor as a royalty, right? So if I sell a product for say 100 rupees, which is the price defined in the tech transfer agreement, I will have to pay to the transferor 10 rupees out of that 10% of the sale value as license as royalty. Now, this could have minimum price being fixed or not. Sometimes it could be a fixed percentage where they say no matter what price you sell it at, I want 10% of the gross revenues. Sometimes it could be the net profits where they say that these are the cost deductions I will allow on the sale price. What is left as a profit, this much percentage comes back to me as royalty. Right? So how you define the royalty, again, there's a lot of party autonomy to it, but the broad principle is it is a percentage of the success achieved by the transferee as part of the tech transfer. Nagaraju, does that answer your question on royalty?
Yes, sir. Thank you.
Okay. Now, there is a slightly more complicated approach to some tech transfer agreements where no royalty exists, may exist, may not exist, licensing fee may exist, may not exist. But what the transferor gets is allocation of equity shares in the transferee company or in a joint venture to be set up with the joint venture partner for the purposes of taking the tech transfer and translating that into a viable business. Okay. Now, a simple example of this could be that there is a fighter jet owner in America. There's a aerospace company in India. We'll call it company A and B. Company A and B decide to set up a joint venture called company C, in which company A, being the US company, transfers technology to the joint venture company, in return of which the joint venture company will allot certain shares to the company A. To be 10% of the shares, 20% of the shares, that is to be defined. Now, in a case where in lieu of tech transfer, equity is being allocated, especially to somebody on the outside, or in fact, for that matter, domestically, the valuation, as we already discussed, becomes very important, right? Now, how does the company A get its money for the tech transfer? It will probably come to them when dividends are announced by the joint venture company at the end of a predefined period. Quarterly, half yearly, yearly, it doesn't make a difference, right? Now, whenever the joint venture company declares a dividend, the proportionate amount due to the company A will be paid to them on account of the shareholding. Right? So here, the consideration is not an immediate cash component, but it is actually allocation of shares. Preserving those shares and ensuring that enough rights are attached to those shares to ensure that the access to those dividends don't go away becomes part of the technology transfer agreement, right? This is done by specifying right of first refusal, affirmative voting rights, either in the technology transfer agreement where shares are allotted or in the corresponding share subscription agreement. But in case of equity allocation along as consideration for tech transfer, it's very critical that the interest or the entitlement or the access to that value of shares is preserved in the language of the agreement itself, right? This will involve not just a deep dive into IP law, but also into company law, right? You will need to know a little bit about share transfer agreements, shareholders agreements, what does the companies have to say, what are special rights or differential rights are attached to shares. So that will then become very critical in advising your clients on how the equity allocation can work for the tech transfer. Right? Any questions so far? Now, where the risk element is in terms of most tech transfer agreements is in tracking the improvements over IP, right? So you transfer IP to an Indian subsidiary for manufacturing fighter jets. But what if the Indian company comes across ideas for improving the parent technology, right? Who owns the IP for that? Now, it's one thing to address that question in the agreement to say that the transferor will own the rights over the improvements over the product or the transferee, depending upon what the parties agree. But the larger question is, how do you verify and enforce that agreement, right? What if tomorrow some IP improvement is being undertaken and it is being given to I don't know, the director's relatives company for them to monetize on the IP improvement? So you need to also put in place in the technology transfer agreement rights for the transferor to inspect the records of the transferee, put in place protocols within the agreement for capturing improvements on IP, for capturing innovation within the transferee company, have a way of tracking it and therefore claiming rights over it. Right? So this could be inspection and auditing rights. It could probably provide templates of agreements to be executed between the transferee company and its employees that are dealing with IP. So you will have to give the full set of protocols necessary to ensure that the improvements over that IP can be traced, number one. Number two, protected so that it's not leaked, it's not taken out. And number three, ensure that the ownership is appropriately addressed, right? Either in favor of the transfer or the transferee, depending upon what the parties agree. But this process of tracking IP improvements and ensuring that it is being managed properly, that is a very critical part of the tech transfer agreement, which must be addressed to a good degree of detail, right? Now, the other thing is, especially if you have either royalty or equity being allocated, you want to ensure that the accounting is being done properly by the transferee company so that the costs are not inflated just to avoid paying out a dividend or just to avoid paying out a royalty. So how the accounts are to be maintained, what are the kind of records that are to be maintained, reserving the rights to the transferor to inspect and verify the accounting records. All of these aspects have to be properly addressed within the agreement, failing which you could have a very elaborate royalty clause, but it may become very difficult to enforce it in reality because you don't have all the collateral rights necessary. Right? Now, a termination of a tech transfer agreement is not difficult. It's fairly straightforward and can be contractually defined. The problem will be when you have joint ownership over IP or IP improvements and modifications. Then what happens if there is a breakup, right? And the parties decide to go their separate way. A lot of tech transfer agreements happen to be silent on this aspect, which makes it very difficult at a later date, right? So one of the things that you can do is to put in place a system for determining how the joint ownership of IP is determined in case there is a breakup of the agreement. One approach is to say that both parties will be joint and equal owners and they can sell and do whatever they want in any part of the world and they can freely compete with each other. The other option is to say that the IP will be valued and whatever is the value arrived at, one party is given the right to buy out the IP share of the other party by paying them that money, right? That's the second option. The third option could be a coexistence arrangement where we say that, okay, I will exist in Asia, you exist in Europe, we will not compete with each other in these markets, right? Or it could be sector specific. I could probably take space and aerospace, you could probably take defense. So how you address the breakup of IP when there is a split in the agreement is also very critical and must be addressed as part of the technology transfer agreement. The next, of course, important element in the tech transfer agreement is the governing law, right? And we already discussed it in great detail today morning. You need to ensure that you've defined the governing law in such a manner that one, you ensure that IP is properly recognized. Right? What you don't want is a situation where the governing law is a law that does not recognize or elaborately confer protection to IP. Right? So have the right correcting law, let the governing law then define how the package is being defined, right? So remember this package here that you see in front of you, while defining that in the agreement, you need to bear in mind the governing law. And then the jurisdiction and dispute resolution, right? Because a lot of times in technology transfer, you don't have the benefit of time in case you realize that there's some mischief being planned. So you need an effective dispute resolution system put in place. So having the right court exercise jurisdiction over the agreement, the right kind of arbitration tribunals being having jurisdiction for dispute resolution, ensuring that those are properly defined is the next leg of the challenge for a tech transfer agreement and very critical because the agreement's value lies in its enforceability. If the enforcement mechanisms are not properly defined, then the value of the entire agreement itself is suspect. So to bring us to the concluding segment of a tech transfer agreement, please remember that a technology transfer agreement is not just intellectual property, right? It is export control, it is customs, it is tax, it is so many other things. So IP is part of every tech transfer agreement, but IP is not the whole and soul of the tech transfer agreement. Right? Now, understanding that it's a broader principle than just this is very important. The second thing to keep in mind is the general principles behind a good contract that we discussed today morning, right? Equally true and equally applicable to tech transfer agreements, more so for tech transfer agreements than any other form of agreements, right? Then what you also need to understand, especially in the context of cross-border transfer of technology, and sometimes even within intra-border tech transfers, is that you will need a multidisciplinary approach because you have to look at export controls, which is a security concern. You have to have people from the tax background examine the tax implications. There could be potential competition law concerns when you have clauses within the tech transfer agreement that prohibits the licensee from procuring spare parts from a different vendor, right? Or channelizing all procurement orders to a particular supply chain. So knowing, the multitude of subjects of law involved and working with that team of stakeholders becomes very critical. Goes back to the point I made earlier today morning. You need to be very clear about the known unknowns. There can't be unknown unknowns. That is something that you can't afford. Right? We probably have about 5-10 minutes to take questions. So yes, if there's any questions or any queries or anybody needs clarifications, the floor is open.
Yeah, so Ashok, while they are coming up with their questions, something very important and very relevant in the context today of bringing out that distinction between what is a tech transfer agreement and what is an IP licensing agreement. So the tech transfer aspect is much broader when compared to any of these IP licenses, which can be a small component of this. And
Right.
as you very rightly brought about, it's not just a contractual relation, but you will have to look at it from the perspective of various other legislations also, like maybe a transfer pricing, the valuation aspect of it, the security aspect of it. And perhaps if we are looking at a particular tech transfer today, we might also have to look into the cross-border data that is traveling technology transfer. So
Absolutely.
that's where we are seeing this has many facets to it. I mean, technology transfer is something which is a buzzword and it's happening all around. And every
Correct.
industry is adopting this. But there is
Correct.
something much more for us in the legal fraternity to learn about. And
Absolutely.
which we have to really delve much deeper into to understand the nuances of technology transfer. So that's
Absolutely.
key learning in today's session.
Thank you, ma'am. So I'll to illustrate this point about how complex tech transfers can be. The one example that I can immediately think of was a artificial intelligence and machine learning based algorithm that would process satellite images and derive certain outcomes. Right. So today, a satellite image is just a photograph.
Yeah.
But to know what you're looking at, whether it is a nuclear installation or is it a factory or is it a car or is it a tank, it involves a lot of image analysis. Now, this was a software that was able to automate some part of this entire image analysis. Overnight, there was a notification by the United States State Department classifying this kind of technology as protected by US export control, right? Now, what that essentially means is that before a US company could transfer technology out of the US to another country, you need the permission of the American government to transfer it out. Now, the complication in this regard is that a particular startup in India, for the purposes of incorporation, may decide that, look, it's easier to raise investments in the US, I'll set up in Silicon Valley, right? Now they go to Silicon Valley, they set up, they raise funding from one of those, angel funds in California. Then they realize overnight that the market for that product was in India, but they're not able to bring it back because of export control, right? So having now a lot of Indian lawyers may not even know that export control is actually something that they need to examine. And export control is so pervasive, especially of the United States, that if I have technology A, which is export control protected, I take the approval of the US government and give it to a company in South Korea. South Korea develops technology B, which in turn leads to development of technology C, D, E, and F, right?
Right.
About 5 layers of technology has already evolved since the export control technology got licensed out. The end technology F is still covered by US export control, right? So a lot of times a tech transfer agreement is entered into not realizing that the entire agreement is probably illegal because you haven't taken the approval of the US government for technology F in the hands of a South Korean company being licensed out. So it's an extremely vast subject. It can't be addressed through one single channel of professionals. And to make matters worse, ever since the Russia-Ukraine conflict started, you also now have the problem of sanctions verification, right? So you could have a situation where you're trying to license technology for manufacturing an oil and natural gas extraction product, right? But if the entity in the Middle East that is getting the technology happens to be connected with a Russian oligarch who happens to be under the sanctions of the United States government, you have to make that exercise of going to the US government OFAC website, verifying the list of sanctioned individuals, doing a due diligence of your prospective transferee to ensure there's no connection. Because if there is a connection later on with a sanctioned individual, then your ability to do business in the world is completely compromised. You won't even have access to the banking channels for cross-border movement of money. So today's tech transfer climate is a lot more security sensitive, a lot more complicated. It just requires an entirely new set of skill set that a lot of Indian lawyers or maybe global lawyers don't have, right? And to upskill is a challenge in itself. So I would say that tech transfer is a specialization in itself. It will require a whole pool of people coming together and saying that we're technology transfer specialists.
And far more of due diligence that is required.
Absolutely, absolutely.
Yeah. Excellent. But good to know that this is an area in itself.
It is.
Probably, we might, I don't know if there are already existing, but we might have some tech transfer boutique firms itself, which will come up.
Absolutely.
Specialized
Absolutely. And I think
long checklists and just like M&A professionals, you might want to have very specific tech transfer professionals.
Absolutely. No, and I think the advantage for today's pool of professionals is that these were specializations that were not even heard of when I graduated law.
Right.
We heard some tech transfer buzzword here and there, but this level of, you have ITAR specialists in India right now. They only do US export control, right? Indian licensed lawyers looking only into that. So I think just the sheer number of career opportunities that have opened up in the field of tech transfer itself is immense.
Yes.
So people don't have to confine themselves to just IP anymore. There are layers and layers that they can go deep into.
Right. And some of our students who are here, some of the law students who are attending here. So this is something that you should watch out for. This is a space that you should all watch out for because this is the most emerging field. All right.
Absolutely.
Questions from the audience? Any the participants? I think should there be no other questions, maybe we can close the session. If you have any other queries, questions, please feel free to write to Ashok on the email address or reach out to him on the number provided here. Or you could also write to us on the EBC platform. And for those of you who are attending the session for the first time today, you can also visit the EBC Learning platform where we all, probably Nagaraju and Priya, some things may have been a little difficult for you to capture through the session today. Maybe you can just visit the website to see some of the self-paced courses that we are offering on intellectual property rights, which is as simple as what are patents, trademarks, copyright. So these are the basic principles underlying these intellectual property rights are provided as a comprehensive course here on an EBC learning platform. So you could just take a look at the courses. You can pick up a few courses if you are interested in learning some. And just continue with the learning. This is a great field to explore. Great opportunities lying ahead. So make the best of it. Thank you. Thank you, Deepak and Vidya, Harshit, Nagaraj, Priya. Thank you all. Hope it was a great takeaway today.
Thank you, ma'am.
Thank you,
Thank
ma'am.
you.
Thank you, sir, for your valuable session.
Thank you. And tomorrow's
Thank you.
session, we will focus largely on IP management, intellectual property management, which will cover aspects like IP docketing, IP due diligence, a small component of IP valuation where you just sort of get a sneak peek into what Ashok was just mentioning today and the importance of IP valuation. So these are some things that we'll be discussing in tomorrow's session. So look forward to meet you at 9:30 tomorrow.
Thank you, ma'am.
Thank you
Yeah,
all.
ma'am. Thank you.
Ashok. Thank you for the wonderful
Thank you, ma'am.
sessions all day today. Thank you for being with
Thank
us
you.
and sharing
Thank you.
some of the most important insights. Thank you.
Thank you. Thank you.